dear learner, we will try to see that how the principles of comity in the extraterritorial application of the competition law goes well in some of the very celebrated decisions of European Court of Justice. Here, it will not be out of context to say that increasingly the competitive trade practices are becoming the part of international hues and colors, and all competition authorities have painted the principles of comity for claiming jurisdiction over any kind of an alleged activity, illicit trade, and thus the comity principles happens to be at the forefront of all the administrative authorities and jurisdictional considerations. The cases of Microsoft, Intel, Empagran, these three cases bears clear testimony to the fact that the European Commission have applied the principles of comity in the right earnest. In case of F. Hoffman, Law Rock Limited versus Empagran 2004 and Intel Corporation versus Advanced Macro Devices 2004 are very important milestone to understand that how principles of comity as one of the most accurate and appropriate doctrine has been working in matters of antitrust and the competition law and extraterritorial jurisdictions. There seems to be many antitrust authorities, but when we take into considerations the other party's interest, which leads to undesired consequences such as forum hopping, divergent results, accumulation of sanctions, misallocation of administrative resources, which have a detrimental effect on other legal system, then immediately the principles of comity sprang up as a positive doctrine to protect the extraterritorial jurisdiction of the competition law. So, primary community legislation in Europe is silent on the principles of comity. However, the principles of comity in positive comity parts and constitutes an integral part of the European Union and United States Agreement of 1991 and 1998. Thus, it can be said beyond any reasonable doubt that the principles of comity has an application in the European Union and as well as United States, all antitrust and competition agreement, as it has been evident from its notification agreements of 1991 and 1998, and it has a spiraling effect among other countries and the third world countries to forge a kind of a meaningful relationship in matters of application of competition law. Dear learner, besides the principles of comity as a part of extraterritorial application of competition law, we have the other doctrine which is known as the spirit of cooperation as a principles of international law, because ultimately the international law is a positive morality and it is based on pacta sunt servanda, and it is that international cooperation and fostering international relationship is one of the important segment of the international law. Seen in this backdrop, we find that European Union's structure is composed of 27 member countries or states. So they cooperate both in internal and external dimension, and thus internal perspective of the Commission under the national competition authorities or European competition network, all European Union member states act in a spirit of cooperation in matters of transnational or extraterritorial application of competition law. The European Commission also cooperate with national courts of each member state insofar as it relates to the application of Article 81 and 82 of the Treaty of Rome 1985. Thus, what we infer, dear learner, that the principle governing the spirit of cooperation are found in Commission's various notifications and circulars. As one circular which I just referred is the integral part of the Comity principle is the European Union and United States Agreement of 1991 and 1998. Article 81 and 82 of the Treaty of Rome and the European Commission's notifications clearly spells out that it will apply the principles of cooperation among all member states of the European Community, including the antitrust and competition activities and laws and policy. The European Commission network deals with cooperation on the application of Article 81 and 82 by providing an effective platform for the exchange of information, assistance, and investigation in all competition law matters and policies. The European Commission, as well as the national competition authorities, also cooperate in the field of merger, control, and all pursuant activities by a pre-notification referral mechanism which has been provided by the European Commission. Thus, from internal perspective and as well as the external perspective, the European Community has entered into bilateral relationship on competition laws and policy issues with third countries and engages in multilateral cooperation on competition policy in various fora. The core provision in this regard is important to be referred is the one which deals with cooperation between Commission, European Commission, and national competition authorities inter se, and it is well recorded and manifested under Article 11 of the Regulation 1 of 2003. On the strength of Article 11 of the Regulation 1 of 2003, the Commission's notice on cooperation within the network of competition authorities is one of the pivotal achievement, and this notification under Article 11 of the Regulation 1 2003 have clearly spelled out, number one, the information shared between the Commission, European Commission, and national competition authorities, and national competition authorities between themselves. Thus, on the strength of Article 11 of Regulation 1 of 2003, it can be said more safely and to be concluded more safely that not only in the internal administrative mechanism but also in the external cooperation, bilateral arrangement, and multinational agreement, we find that extraterritorial application of the competition law finds a very positive place under the doctrine of cooperation or the spirit of cooperation as a manifestation of international law vis-a-vis the extraterritorial jurisdiction of competition law in the European Union, besides the applications of three doctrines. Thus, dear learner, in conclusion, what we say that we refer to the basic legal framework of the extraterritorial application of competition law in European Union. We refer to a large number of the cases. We refers to the economic entity doctrine. We refer to the implementation doctrine, and we also referred the application of the effect doctrine with a very probing eyes and in a very dispassionate manner, and pulled out some of the cases which provides some space, leeway, and leverage to the effect doctrine of the United States antitrust law. However, that the criticism that it is not recognized explicitly by the European Court of Justice, notwithstanding the effect doctrine is now universally recognized concept of the European Union's competition law and policies in matters of extraterritorial jurisdiction. Thus, the consequences which follows that the uncertainty surrounding the legal status should not be overplayed, as the scope of implementation and economic entity doctrine should be more than sufficient to assert the subject matter jurisdiction over purely non-European undertakings involved in an alleged illicit activity that has an effect and in the European Union. Thus, by way of European Union member states of 27 countries have concluded a large number of bilateral cooperation agreements and multilateral agreements in matters of extraterritorial application of competition law under the principles of comity and principles of cooperation as a part of the international law. Thus, these two principles of comity and the principles of cooperation, is acting as a driving force behind all antitrust cooperation in multinational and antitrust fora. As a corollary, what we find that the effective spread of the best practices the effective spread of the best practices of the extraterritorial application of competition law in European Union will have demystified all philosophical gulf, and from its conduct to the effect, it has been applying the effect doctrine to its jurisdictions, and the extraterritorial application of European Union competition law may remain a subject of discussion. Nonetheless, the European Union's approach involves implementation doctrine, single economic unit doctrine, effect doctrine, principles of comity and the principles of cooperation, and the Court of Justice, European Court of Justice, in catena of cases have been very meticulously culling out and embellishing the entire jurisprudence of the competition laws and policy in a very proactive and a positive manner, and giving a wider application of extraterritorial application of the competition law through the instrumentality and of the doctrines and principles in a very amicable and an effective manner. With this, dear learner, I conclude my lecture and I wish a happy learning to you. Thank you very much.